Hey, I'm firearms attorney Gilbert Ambler, and I'm back today to talk about whether it is constitutional for the government to prohibit you from carrying a firearm inside your vehicle. And of course, we're all hoping and waiting for the day that we get national reciprocity. But up until then, if you don't live in a state, if you're not fortunate enough to live in a state that has constitutional carry, it's very likely that you're going to have to comply with state licensing laws. And especially on the East Coast, as people travel back and forth from different states, they run into a lot of states, at least in the northern part of the East Coast, and this is, I guess, true on the West Coast as well, they run into a lot of states that require licensing. And what I want to talk about today is the constitutional nuance that occurs when we're not talking about a state that requires licensing to generally carry concealed, but whether if you are simply driving through a state, whether it is constitutional to restrict you from having a firearm in the vehicle, and specifically a loaded firearm inside the vehicle if you're traveling through the state. Because I want to remove from this consideration, remove from this topic today, the Federal Safe Passage Act. We could do another video about that. That's a law that could arguably get you from one place you could legally possess a firearm to another place, provided the weapon's unloaded and you're not stopping in the state that doesn't recognize your rights. Instead, what we're focused on, again, very narrow topic, is going to be carrying a loaded firearm in a state that requires a license to carry, and whether it is constitutional to carry a loaded firearm in a vehicle without having the appropriate license. Before we dive into this subject, as always, if you have not yet hit that subscribe button, what are you waiting for? Go ahead, hit the subscribe button, like, comment with your thoughts, share with your friends. That way you and your friends can keep getting this important Second Amendment related content. We're going to start off, and as many of you probably know, I practice in both Pennsylvania and Virginia. We're going to start off with something that Virginia cases have called the saddlebag defense. And this saddlebag defense came in the early to mid 1800s in Virginia, where the first concealed carry restrictions were put into place. Back then, it was considered dishonorable to carry a concealed weapon. In essence, the idea was if you were carrying it concealed, then people had a reason to be afraid of you, because if you would only carry it concealed if you were up to no good, essentially. That everyone thought it was normal to carry weapons, and if it's normal to do so, you'd do it openly because no one would be surprised by that. Of course, society's viewpoints on this have somewhat shifted over the years, and now perhaps it is more widely recognized as acceptable to carry concealed if you're able to do so. But because of this early to mid 1800s, roughly 1830s restriction on carrying a concealed weapon, Virginia, in one of the first cases considering it, talked about the saddlebag defense. And the defense was this: if you wanted to travel by horse, you could carry your weapon with you and you didn't have to have it open and exposed while on horseback. You could put it in the saddlebags. And that was an exception to the laws restricting concealed carry. That exception in modern form still applies today. In Virginia, you can carry a firearm in your personal motor vehicle in a secure container, which would include a latched glove box or latched center console, read the modern equivalent of a saddlebag. What about other states, though? For example, Pennsylvania has a broad ban on handguns being carried inside vehicles in a situation where you don't have a valid or recognized license to carry. Now, interestingly enough, this has been challenged by the Suarez case. In the Suarez case, the district court judge initially enjoined the Commonwealth of Pennsylvania from enforcing the prohibition on vehicle carry. And in essence, what the court said is that prohibition is facially unconstitutional. We can't imagine a scenario where it would be constitutional to just broadly restrict people from having firearms inside their vehicles. Notably in Pennsylvania, this broad restriction applies on handguns inside vehicles, irrespective of whether they are loaded or unloaded, unless you fall into a particular exception. And the court said this broad prohibition is facially unconstitutional. Now, unfortunately, the decision of the district court was stayed by the district court, and then that stay was upheld on appeal, meaning that at least as this case continues forward, Pennsylvania will still be able to enforce these prohibitions. And unfortunately, my office deals with these prohibitions all the time. We regularly get calls from people that come into Pennsylvania. Maybe they're carrying on an out-of-state permit. Maybe they have a Virginia concealed handgun permit. Don't realize Pennsylvania isn't going to recognize it. They get into Pennsylvania. They get pulled over. Officers find out they have a firearm. They get arrested for a misdemeanor of the first degree in most scenarios, which is punishable by up to 5 years in prison. And if you are convicted, you'll lose your right to possess firearms under both state and federal law. And sometimes, if they're not eligible for a license to carry, they might even be charged with a felony offense. So there are serious consequences to carrying a firearm in a vehicle in Pennsylvania if you don't have the valid or recognized license or permit to carry. That being said, what about these constitutional challenges? We just talked about the Suarez case where the district court judge said, yes, it's probably unconstitutional, but then stayed his decision on appeal to allow Pennsylvania to continue enforcement as the case moves on. What about other people that have actually been charged? Well, there's a lot of people out there that feel that the Pennsylvania Superior Court is fairly anti-criminal defendant, meaning they often decide things in favor of the government. And there has been a recent string of cases that are no different. And these are cases that involve this firearm inside a vehicle, firearms to be carried without not to be carried without a license under Pennsylvania. Again, that misdemeanor of the first degree, punishable by up to 5 years. And in these cases, one of the most egregious ones just came out at the end of December, in my opinion, most egregious. It came out at the end of December, right after Christmas. It is an unpublished opinion, which fortunately means it is not a precedential opinion. But in this situation, a man from Virginia was in Philadelphia. He came into contact with law enforcement. Turns out he didn't have a valid Pennsylvania license to carry. I'm not clear on whether he had a Virginia license to carry or not, or concealed handgun permit out of Virginia. Ultimately, however, he was convicted of 2 counts of firearms not to be carried without a license, one for a handgun, one for a rifle. He was sentenced to 11 months and 15 days, up to 23 months of incarceration for this. So pretty serious. I mean, almost a year behind bars at the minimum. In response to this, one of the things that he alleged as error was the fact that Pennsylvania had not proved that the rifle actually met the definition of a firearm under Pennsylvania law. And this is an interesting issue because Pennsylvania, as I said, it generally prohibits the carry of handguns. It also prohibits the carry of short-barreled rifles and short-barreled shotguns unless you have a valid or recognized license to carry. It does not generally prohibit the carry of a rifle inside a vehicle, provided the rifle is unloaded. So the question is, was the rifle that he had in his vehicle, for which he was convicted, actually a short-barreled rifle? And interestingly enough, the Commonwealth, the prosecutors, did not present any evidence of the barrel length. They would have had to prove that the barrel length was under 16 inches or the overall length was under 26 inches. Did not present any evidence on this point. This Mr. Lamata alleged it as error, went up to the Court of Appeals, and the Court of Appeals said, doesn't look like a problem to us because the trial judge could see the barrel on body cam, and the trial judge must have thought that the barrel looked like it was over 16 inches. I don't know for a fact whether the barrel was or was not over 16 inches, but I do think that's something that the Commonwealth should have had to prove. I think it's pretty wild that a trial judge could simply glance at a body cam and be like, yeah, that looks like it's over 16 inches to me. You're telling me that trial judge, without a dowel rod and a measuring tape, could tell me whether it was a 14.5-inch barrel or a 16.25-inch barrel? I find that unlikely, but nonetheless, the conviction was upheld. The other thing that they alleged was a violation of the Second Amendment. They said, hey, you're prohibiting me from carrying inside a vehicle without a license. And the court essentially said, well, Brune said that broad-based shall-issue licensing is permissive, and that's what we have in Pennsylvania. Therefore, he should have gone and gotten a license if he wanted to carry firearms. I think there are some issues with this decision. Number one, they don't separately consider the Pennsylvania Constitution. Pennsylvania's Article 1, Section 21 arguably should have provided stronger protection than the Second Amendment for this particular charge. The court seems to treat Article 1, Section 21 and the Second Amendment as one and the same. The second issue I see with the court's reasoning on this is that Pennsylvania, although set up largely as shall issue, actually allows consideration of character and reputation. And because it allows consideration of character and reputation in obtaining a license, it arguably isn't quite as straightforward shell issue as Brune apparently signed off on. If you are in trouble for one of these cases, it's very important that you get a lawyer that understands the laws and understands everything, the constitutional background at play. If you enjoyed this content, go ahead, hit that subscribe button. Until next time.